Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today because you have a case in County Court at Law number 2. The case that you have is a criminal case. Criminal cases are divided into felonies or misdemeanors. The case that you have in this court is a misdemeanor case because we only handle misdemeanor cases. The felony cases are commonly referred to as your most serious type of criminal offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they are not as serious as the felony cases. If you had a felony case, felonies are divided into 5 categories. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If you was charged or if you was convicted with a state jail felony, the range of punishment would be a minimum of 6 months in the state jail to a maximum of 2 years, and a fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment is a minimum of 2 years to a maximum of 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment is a minimum 2 years to a maximum of 20 years in the state penitentiary and a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is a minimum of 5 years to a maximum of 99 years to life and a fine up to $10,000. If you're convicted of a capital murder, then the range of punishment, if you're convicted, is life or death. Life in the state penitentiary or death by lethal injection. Now, the case that you have here is not a felony case. It's a misdemeanor case. Now, misdemeanors are divided into 3 categories. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Class C misdemeanors are cases that's normally handled in the JP court or the city court. However, they come to this court when they are appealed from the JP or the city court. Now, if you're convicted of a Class C misdemeanor, the range of punishment is fine only. That is, we cannot give you jail time. However, if you do not pay your fine, then a capious pro fine can be issued, a warrant for your arrest, so that for you to sit out your jail time in jail, sit out your fine in jail. Now, if you're convicted of a Class B misdemeanor, the range of punishment is minimum 0 days to 180 days, which is 6 months in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, the range of punishment is 0 days to 365 days, which is a year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. As a defendant in a criminal case, you have rights. One of the rights that you have is a right to have an attorney. Now, the paperwork that you have been given, the paperwork that has been given to you on the tablet, on the first page, it says, judge's explanation of rights to defendants without attorney. This document will explain to you the rights that you have regarding your right to have an attorney. And it starts off by saying, as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Number 3, you may represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset. Reset means you'll be given another court date. So the case will be reset to give you time to do so, to hire an attorney. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. If you desire to represent yourself, and if you waive your right to have an attorney and desire to represent yourself, you may not speak to the prosecutor. Now, the prosecutor, that's the assistant or the district attorney. We have two assistant district attorneys who's sitting at the table before you. They're the prosecutors. Now, you may not speak to the prosecutor about your case unless you sign a written waiver. A waiver means you're giving up your right, a written waiver of your right to be represented by an attorney. So if you give up your right to be represented by an attorney, if you desire to represent yourself, you sign a written waiver, and then you will be allowed to talk to the prosecutor or prosecutors about your case. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, is in bold letters, it states defendant's choice, mark initials next to only one choice. If your choice is, I want to reset my case to hire my own attorney, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. If you've already been appointed a court-appointed attorney to represent you in this case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is you would like to waive your right to the attorney, which means give up your right to the attorney and to represent yourself, then you'll place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant. And you will place today's date, which is January 31st of 2023, on the line that's titled date. Now, for those of you who will be giving up your right or waiving your right to an attorney and you will be representing yourself, then you would have to read and sign the next document. And that next document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And I will go over this document with you. And it reads, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 31st day of January of 2023 by the County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you will sign your name above the line that is titled defendant and you would date it today's date above the line that is titled date. And the day's date again is January 31st of 2023. Now, as a defendant in a criminal case, you also have other rights. One other right that you have is a right to have a trial by jury. Where those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to sit as jurors in your case, and they will decide, after listening to all the evidence, whether or not you're guilty or not guilty. You also have a right to waive your right to have a trial by jury, which means to give up your right to have a trial by jury. And by doing so, your case will still come before the judge or the court in one of 3 ways. One way it will come before the court is by way of a trial. That's a trial without a jury. It's a trial by judge only, and we call that a bench trial. Now, you also, and the judge will listen to the evidence. After listening to all the evidence, the judge will decide whether or not you're guilty or not guilty. You also have a right to enter a plea. In essence, you waive your right to have a trial by jury and a trial by judge, and you would like to enter a plea. Now, you can enter one of 3. You can enter one of 3 pleas. You can enter a plea of guilty. If you enter a plea of guilty, you're telling the court you committed the offense that you've been charged with. Or you can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or if you enter a plea of no contest or nolo contendere, it means that you will not be fighting or contesting the charges. Now, if you enter a plea of guilty or no contest, your case will come before the judge by way of a plea. Now, what a plea is a plea bargain agreement. It can come before the judge by way of an agreed plea bargain agreement. That means that you and the state or the district attorneys or the prosecutors have reached an agreement to settle your case. We call that a plea bargain agreement. Now, the case will come before the judge. The judge doesn't have to follow the plea bargain agreement. If the judge does follow the plea bargain agreement, if you decided that you would like to appeal your case within 30 days, then you have to get permission from the judge to appeal your case, okay? Now, if the judge gives you permission to appeal your case will be appealed. That is, they will have a higher court than this court that will look at the case and see whether or not you should have been found guilty or not guilty. They will determine whether or not the court committed an error by convicting you or you were wrongfully convicted. And if they decide that you was wrongfully convicted, if they ruled that you was wrongfully convicted, that means they grant your appeal. Then they could simply find you not guilty, or they could send the case back down to this court in order this court to give you a whole new trial. Now, if they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals, which is above us. You can appeal it to the highest criminal court in the state of Texas. That highest criminal court is called the Texas Court of Criminal Appeals. It is located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. Pro se means you'll be filing it on your own without the assistance of a lawyer, and you'll be asking them to review your case to see whether or not your appeal should have been granted, whether or not you were wrongfully convicted, or whether or not the court committed an error by convicting you. If they grant your pro se petition, they can simply find you not guilty. And then if they find you not guilty, the case is over, or they could send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your pro se petition for discretionary review, then at that point, the conviction will stand. So just to recap what we've just said, first of all, we talked about you had a right to have an attorney. You can either hire an attorney, see if you ask for a court-appointed attorney, or you can waive your right to an attorney and represent yourself. You have a right to have a jury trial. You also, if you waive your right to have a jury trial, then your case will come before the court or the judge. You can have a bench trial, or if you waive your right to a bench trial and a jury trial, and you enter a plea, you can have an agreed plea bargain, which is an agreement between you and the state to settle your case. Now, you also, if you're in the state, have not been able to reach an agreement to settle your case, and you still want your case to be settled by the court, you can do what is called an unagreed plea bargain agreement. That means that you and the state have not been able to reach a settlement, and you want the court, the judge, to determine what your punishment will be in your case. We call that an unagreed plea bargain agreement. Now, you also have a right to have witnesses to come to court. And that chair over there, we call that the witness stand, the one with the microphone. Witnesses, they'll sit in that chair. They can testify either for you or against you. If you're representing yourself, you could ask some questions. If you have an attorney, the attorney could ask some questions. We call that either direct examination or cross-examination. Now, you can waive or give up your right to have witnesses to come to court as well. Now, because you waive your right to have witnesses to come to court, you will not be calling witnesses. However, that does not mean that the state or the district attorney will not be calling witnesses, because they will be calling witnesses in the case that they have filed against you. Now, you also have a Fifth Amendment right against self-incrimination. What that means, you have a right not to testify against yourself in your trial. We call that the fifth. People say, oh, I'll take the fifth. What that means is I'm not going to testify against myself in my trial. And by doing so, the district attorney's office or the state cannot force you to testify against yourself. However, if you waive your right or give up your right, your Fifth Amendment right against self-incrimination, then you can testify, or you will be testifying against yourself, or you'll be testifying in your case. You also have a right to have discovery. Discovery means that you have a right to see the evidence that the state has against you. Now, that means you have a right to see the documents, the exhibits. You have a right to see witness statements, a right to have access to videotapes or video recordings, or any type of evidence that the state will be using against you or have against you in your trial. Now, you also have a right to waive your right to have discovery, which means you have a right to not see the evidence if you desire that you would not like to see the evidence. You'll be waiving your right to have discovery. Now, everyone that's here for your misdemeanor case, you're here because at one point you were arrested and you're here and you're out on bond. You're either out on a cash bond, that means that you paid the full amount to get out, or you're out on a surety bond, that means that you paid a portion of the full amount to a bondsman, and you're out on a surety bond. Or you're out on what we call a PR bond, a personal recognizance bond, which means that you did not have to pay any money to get out. You promised that you would appear in court. Now, every day that you spent in jail, that jail time can be used as credit toward your punishment. So, for example, if you and the state have worked out an agreement that the agreement is for you to serve 5 days in jail, if you've already served 5 days in jail, you would not have to serve any more time in jail because you'll be given credit for the time that you've already served. Therefore, you'll be given credit for time served. Now, if they offer 7 days in jail and you serve 5 days, that just simply means that you would have to serve 2 days, because we subtract the 5 days that you've already served from the 7 days. So you'll be required to serve 2 days. Now, every day that you spent in jail also be credited as $100 per day that will go toward your fine and court costs. So, for example, if you and the state has worked out an agreement for you to pay fine and court costs of $500 and you serve 5 days in jail, that means you would not have to pay anymore. You wouldn't have to pay the fine and court costs. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, the $500 will be taxed and retired. Now, if they are offering fine and court costs of $700 and you spent 5 days in jail, you'd have to pay $200, because we will subtract the $500 for the 5 days in jail from the $700, which gives us $200. Now, you'll be required to pay it on that day. Now, if you cannot pay the $200 on the day that you're convicted or that you enter your plea, then we can put you on what is called a payment plan. That is, we can allow you to pay it off in monthly installments over a period of time. Now, let's say even if we do that, you cannot pay it off. Then the law allows the court to convert your the fine and court costs to community service. So for example, you will be given $12.50 for every 1 hour of community service that you do at a nonprofit organization. So for example, if you work 8 hours in one day at a nonprofit organization, 8 hours of community service, then that's $100 that will go toward your fine and court costs. Okay. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is the program for first-time offenders. If you haven't been in trouble before, they have a program where the district attorney's office will dismiss your case. And you would be placed into a program that is ran by the probation department. And once you complete that program, then you can get it expunged from your record. Expunged means wiped off, deleted, or erased from your criminal record. And in order to get into that program, the pretrial diversion program, it has to be your first offense. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And you have to have an attorney to assist you at getting into the program. If you are a veteran of any one of the branches of the United States military, there's a program that is called Veterans Court. The only requirement is that you be a veteran. Then, if you get into the program, in Veterans Court program and complete the program, I think the same thing will happen like the pretrial diversion. It's part of a pretrial diversion program. All right. Now, this court, County Court at Law number 2, has a program that is called the Community Safety Initiative, a program that I started in March of 2017. Actually, it's going to be 6 years this year. That program is designed to address the issue of recidivism. Recidivism means when people commit crimes over and over, how do we stop it? Well, we stop it through the Community Safety Initiative. With the Community Safety Initiative, we have a partnership with several agencies in our community. One partnership that we have is with the Spindletop Center. Young people that you see sitting over in the jury boxes from the Spindletop Center. And we'll have someone that will come before you today and tell you a little bit about the program. But basically, with that program, Spindletop will be able to address a person who have mental health needs. For example, you might suffer from anxiety, depression, schizophrenia, bipolar, or a whole host of other mental health issues. They can address that. And the way they address it is, one, they'll give you a private interview. And then once you get a private interview, they will do what is called an assessment. And based on that assessment, they develop a treatment plan. The treatment plan could either be outpatient or inpatient treatment. Spindletop also has a program that is called ATAR, and ATAR is a program that deals with drugs and alcohol abuse. Also, our local Alcohol and Drug Abuse Council has a program that is called OZAR. OZAR also deals with drug and alcohol abuse. And basically, both programs, you'll be given what is called a screening, and then an assessment. And based on that assessment, they will develop a treatment plan, either outpatient or inpatient, and you'll be referred for either outpatient or inpatient treatment. If you are unemployed or you're looking for a better job, then we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in one of those areas, then they will assist you at getting a job in the area that you're trained at. Now, if you have not finished high school, well, and you desire to get a GED, graduate equivalency diploma, then CICE also has a GED program. Now, all of these programs that I just mentioned are free. It does not cost you anything. The only thing you have to do is have a desire to be in the program. And the other benefit is, if you're in one of these programs can be used as community service. So for example, let's say you were ordered to pay a fine and communities and court costs. You cannot pay the fine and court costs. You're ordered to do community service. Let's say if you're in a program, say for Spindletop or a job training program, or you're getting your GED or drug or alcohol abuse program, any one of those programs, every hour that you participate, 1 hour is going toward community service and $12.50 is going toward payment of your fine and court costs. So in essence, you're doing one thing, but you're getting credit for three things. You're killing three birds with one stone. That is, you're in the program, you're getting community service hours, and you're paying your fine and court costs. And as I mentioned, all of these programs are free, and these programs is here in County Court at Law Number 2. And I tell people this all the time. When you come to County Court at Law Number 2, we do not have court as usual. We have unusual court. It's not because we're different. It's because we're trying to make a difference in the lives of the individuals that come before this court, and we're trying to make a difference in our community, in the Jefferson County community, the community in which we live. We believe that with this program, we do not just arrest the problem, we address the problem. That is, we do not just give time or jail time, we take our time. And we believe by taking our time, we can produce productive people. And if we produce productive people, we believe that productive people would not commit crimes. Why? Because they have too much to lose. So if you're interested in these programs, folks from Spindletop have brochures. We also have information that we can give to you so that you can get into the job training, job placement program, or also the GED program, as well as the drug abuse and alcohol program. So at this time, Deputy Hinton and Kristen and Ashley is going to come forward. They're going to tell you a little bit about the program that they have at Spindletop.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state, commissioned by the sheriff's office here. This is my coworker Chris and Ashley. Now, both these young ladies are qualified mental health professionals. The reason we are here today in this courtroom is because the judge cares about every single person who comes before the bench. What the judge has found is those who appear with legal issues commonly have health, substance use disorders, sometimes just a lack of community resources to help you in your particular situation.
I know the judge mentioned several different things. Commonly, what we usually see is anxiety, depression, stress, and things that you deal with in your day-to-day life. Things that we all deal with in our day-to-day life. It's not exactly become easier when dealing with the court process. And that's what we hear. Whenever you guys came in, I walked around the community around this. This is a baseline to living system. Any information you put on this document, it is protected under state law. The only thing that's allowed me to do is contact you once, whether by text or by call, it's your choice. Or speak with you privately in the back, whenever the judge calls recess. Now, when you speak with us privately in the back, if there's specific resources you know about, like you said, there are a lot of different funds in this area. They just may not be well advertised, but they are well funded. So if you know something you need specific, or if just per se, like that stresses me to be a little bit too much, we can move back there, we can talk. It doesn't necessarily have to be an assessment. We can do an assessment, but we can also just take a moment to breathe and just work through whatever you need to work through the setup, whatever you have to set up. So
Maybe this is your first time to be here. Maybe it is your 10th time to be here. There's still hope. This program offers resources that will help you in your situation, but we don't know where you are in your walk in life. So we're going to ask you to do something. We're going to need you to share that need with us on this document that she gave to you earlier. It is separate from the court documents. It will not be shared outside of your permission, but if you'll put the necessary information, we will follow up with you, we will talk to you, and we will help engage and get resources that would best fit your particular situation. But we're gonna need you to reach out and share that need with us.
The biggest thing we want to take away is that we will work as hard as you will be on yourself. And you're already here, you made it here today. That's a big thing. A lot of people didn't make it here today. So we're gonna use this moment. We're only allowed in 2 courts here in Jefferson County. We're only active in Jefferson County. So the odds of you guys seeing us are very low. So why not? We can make this into something productive. Now, whenever we walk around and pick that up, he's gonna hand out this brochure. The thing about that brochure, at the bottom of this, you also see, you're gonna see 3 numbers. Those are also on that brochure as well. One of those is a 1-800 crisis number that is active all over, or almost all over Texas. So a lot of people coming into court, they don't necessarily come from Jefferson County, but that doesn't mean that, you know, you don't deserve the same amount of help or resources from this area. So if you need to, if you are ever in an unsafe situation, or you find yourself, you know, in a crisis or just stressed out or on the side of the road, you don't know who to call, you have that pamphlet, you can call that 1-800 number. 9 times out of 10, they'll be able to get you connected to the most helpful resource in your area, even if it's supposed to get help at that moment. So we're gonna hand those out, I'm gonna pick those up. If there's any questions, we will be there. We're gonna be here to the end of court to let me or Ashley or Steve know. And yeah.
Thank you, Your Honor.
Okay, thank you. Now, ladies and gentlemen, the paperwork that you have on, you also have, for those of you who will be requesting to apply for a court-appointed attorney, you have a document that is titled Jefferson County Affidavit of Indigence. On that document, it has to be filled out completely. It says this portion to be completed by or with defendant. Then you fill out that information, ask for your name, date of birth, address, phone number. Now, if you receive, it also asks whether or not you receive any governmental benefits such as Medicaid, SSI, SNAP, TANF, or public housing. Now, if any of that applies, then you would check it. If it does not apply, then you just don't check it. It also asks whether or not you're employed, where you're employed, what type of work you do. Next line talks about the number of hours per week that you work and how long you have worked on that job. It also asks your marital status, whether or not you're single, married, divorced, widowed, or separated. You will check off one of those boxes. If you're married, then you'll write your spouse's name, middle initial, and last name. If you have any children that are dependents from the age of 18 years old or younger, then you will write their name and their ages. When it asks for residence information, it asks whether or not you rent, own, reside with family members, or if you're homeless, and you will circle the box that is appropriate for you. Now, at the bottom of this document, the bottom left-hand side, it's titled Monthly Income Assets. Now, what that is asking for is your monthly income, what you make per month, not what you make every 2 weeks. So whatever you make in every 2 weeks, you're gonna calculate that into what you make per month. And first is, it asks for your take-home pay. You will place that in the column next to it. If your spouse is working, then you'll place your spouse's take-home pay. If you do not have a spouse, or if the spouse is not working, you place 0. Now, where it says child support, if you receive child support, you put the child support amount that you receive per month. If you don't receive child support, it'll be 0. SNAP, which is food stamps, you'll put the amount that you receive per month. If you do not receive any SNAP, then it's 0. If you receive Social Security or disability, you put the monthly amount in the column next to it. If you do not receive Social Security or disability, then the amount will be 0. If you receive any type of other government checks or governmental checks, then you put the monthly amount. If you do not receive a check from the government, then it'll be 0. And then it says other income. If you work in another job, you have another source of income. You put what you're making per month. If you do not have any other income, then it'll be 0. Assets, if you own a car or home, etc. You put the amount of that asset in the column next to it. Now at the bottom where it says total monthly income and assets, you will add up everything in the columns above it, and then you'll put the total amount of monthly income and assets. Now, to the right side of that document, at the bottom, it's titled monthly expenses. So if you rent, or if you pay mortgage, you're gonna put your monthly amount in the column next to it. If you have utility bills such as electric, gas, or water, you're gonna put your monthly amount in that column. Now, if you do not have any of these expenses, you're just gonna put 0. If you have to pay child support, if you're paying child care expenses, then you put your monthly amount in the column next to it. If you do not have that, it'll be 0. And your total food expenses in the next column. And that will be what your total food expenses are per month. If you do not have any, then it'll be 0. If you have transportation costs, now with transportation costs, you're asking for, if you have a car note, if you have car insurance, if you have to pay for gas or fuel, then you will add that amount, add your total amount, and then put it in the column that says monthly, or that says transportation costs. Now, if you have to pay a phone bill, either cell phone and or house phone, then you add that up, what you're paying per month. If you're paying probation fees or parole fees, you'll put that in the column where it says probation fees. If you have any medical expenses or health insurance, whatever you're paying per month, you put it in the column next to that. And then at the next column, it says minimum monthly credit card payment. Now, if you're paying a credit card, put the minimum amount that you're paying per month in the column next to it. And then when you get to the bottom where it says total monthly expense, you're going to add up everything in the columns above it and come to a total. Now, on the next page, where it says defendant's oath, you're going to place today's date of January 31st of 2023, and then you'll read that oath, you'll sign it where it says defendant's signature, and you will date it today's date, January 31st of 2023. And at the bottom where it says unsworn declaration by defendant, you'll fill that information out where it says your name, your date of birth, your address, and you have to declare under the penalty of perjury that the foregoing is true or incorrect, executed in Jefferson, and you put Jefferson where it says county, Jefferson County, on the 31st day, and the month is January, the year is 2023, and that will be all that you would have to do with this form. And then the bottom portion, the court will, once the court get the information from you, then the court will determine whether or not you meet the eligibility requirements or you do not meet the eligibility requirements for the appointment of a court-appointed attorney. So if you need any assistance with the form, then we have our court personnel who will be available and happy to help you with filling out the forms. Now, while you are doing that, this court is going to be in recess, which means that we'll give you time to fill it out. And while it's going to take us some time to get the forms up from you and evaluated, in the meantime, if you need to use the restroom, there are restrooms in the hall outside the courtroom. If you open that door that you came in, you can walk straight for the men's restroom, and the women's restroom is on the opposite side of the hall in front of the 172nd District Court, Judge Templeton's court. So at this time, the court will be in recess, and as I mentioned earlier, we have individuals from our court personnel who will be available to assist you at filling out the forms, okay? So at this time, the court will be in recess, and then those who need help, just simply raise your hand and we'll get someone to assist you with filling out the form.